if you or a family member has been put into deportation proceedings, put your case on in front of the immigration judge, and the judge denied the case, you will be given 30 days from the date of that decision to file an appeal with the Board of Immigration Appeals. The Board of Immigration Appeals is sort of the Supreme Court of Immigration Court that will review the decision from the judge. The BIA is in Fallsbrook, Virginia. A BIA appeal, if you're not detained in custody by INS, typically takes about a year, give or take, to process. The BIA appeal will review the immigration regulations and laws in connection with how the judge adjudicated your case. And many times the cases will be attacked on legal grounds. They may be attacked on grounds that the judge made statements that questioned a respondent's credibility and made an unfair credibility determination based on the evidence. And finally, many of these cases require a showing of extreme hardship to a family member to try and win their deportation case. And if the immigration judge made a finding that the hardship was not sufficient, that would probably be one of the most common ways a case would be appealed to the Board of Immigration Appeals. If your Board of Immigration Appeal is denied, there is a final form of review. In California, it would be to the Ninth Circuit Court of Appeals in San Francisco. And the focus on the Ninth Circuit petition as opposed to the BIA appeal is the Ninth Circuit Court does not have jurisdiction to judge based on immigration regulations. So if all you were doing was saying that the judge misapplied an immigration regulation, you could not make such an appeal to the Board of Immigration Appeals. You can only appeal to the Board of Immigration Appeals if there is some constitutional issue. And constitutional issues that we would typically present to the Ninth Circuit Court of Appeals would have to do with due process violations. It would have to do with ineffective assistance of counsel. It would have to do with credibility determinations. It would have to do with whether or not a particular immigration regulation is constitutional or not constitutional. So although you're dealing with the same underlying facts in the case, it has to be analyzed from a different perspective when it goes to the Ninth Circuit Court. A Ninth Circuit petition can take between 1 and 3 years to process on average. So if somebody gets put into deportation proceedings, by the time they have completed the deportation case, the Board of Immigration Appeal and the Ninth Circuit petition for review, you could easily be looking at a process that's taking 3, 4, 5, 6 years. So it is something that people strongly do want to consider if they want to fight as hard as they can to stay in this country as long as they can.